Okay. Today we're going to talk about the 10 most important issues a borrower needs to address in a commercial mortgage. What we're going to do is we're going to talk about the first 5 issues first, then we're going to take a break, and then we're going to go over the last 5 issues. The first issue I want to talk about is the leasing section of a mortgage. Now in your standard form mortgage that you have is in section 1.10 of the mortgage. And as you will see, this clause states very simply that the borrower may not enter into any leases or any lease amendments without the consent of the bank. And if they do, that will be a default under the loan, which will entitle the bank to foreclose. Now, this is problematic for a number of reasons, having this type of clause. Number one is cost. I mean, every time you go back to the bank for approval, they're going to give it to their lawyer, and you're going to be paying them, okay? And you know, if you have a retail store, a retail strip center that has 30, 40, 50 tenants, this is going to get very expensive very quickly, especially when you do amendments, which may be minor amendments that mean nothing, and you're paying thousands of dollars to the bank's attorney. So that's one issue about the cost. The second issue is a timing issue. If you have to give a lease to the bank for approval, it may take them 3 weeks to get back to you. Now during that time, you may lose the tenant because he doesn't want to stick around for 3 weeks. So at a minimum, what we do is you should ask for a clause in the mortgage stating that there's a certain period of time where the bank has to get back to you. And if they don't get back to you, it's deemed approved. So for example, often I'll ask for 5 days. I'll say, look, I'll give you the lease for approval, but if you don't get back to me within 5 days, then it's deemed approved. I don't have to deal with you anymore. Okay. The third problem with giving the lender approval rights is that you open up a whole can of worms with comments that the bank and the bank's attorney is going to give you. In my experience, you know, if the bank, well, look at it this way, there are practical attorneys out there who know that they really shouldn't give a lot of comments and only give you comments if it's very important. But there are other attorneys out there who feel like they want to be part of the process, and you know, they're going to give you comments, okay? And this especially comes up if it's outside counsel versus in-house counsel. If you have someone who's outside counsel, they're charging a big fee to review the lease, okay? I mean, it's New York City, we're here in New York. They may charge up to $1,000 an hour to review the lease. So if you can think about it, if the lawyer spends 3, 4, 5 hours on the lease, then he speaks to his client, the bank, and the bank says 2 things to him. 1, do you have any comments? And 2, how much is your fee? And the attorney says, well, it's a $5,000 fee and I have absolutely no comments. That will never happen because the attorney will feel pressure to justify his fee. Okay, so he will come up with comments. And if he comes up with, say, 10 comments, now I got to go back to the tenant. I got to get them to agree to it, which I never will, right? Because they're going to agree to a couple of them, but they're going to reject other comments. I got to go back to the bank attorney and try to get him to modify his language. And it goes on, becomes a complicated scenario and an expensive one as well. So you don't want to get yourself into that situation if you can avoid it. So what do I recommend? Number one, I would recommend, if possible, to get what I call market rate language in the mortgage. And you can get this if you have a client, or often get this, if you have a client who's very sophisticated, who owns a lot of property, and it basically states as follows. Now remember what the mortgage says. The mortgage will always say that you can't lease it without the consent of the lender, and then like all of us who are lawyers, will write, notwithstanding the foregoing, or notwithstanding anything herein to the contrary, comma, borrower shall be permitted to enter into any lease without the consent of the bank, or without the approval of the bank, provided such lease is at market rentals and on market terms. And the borrower may enter into any lease amendment if it's on market rate terms as well. Now, if you can get that, that is very good for the borrower. Because now, if you think about it, any lease, if I'm representing the borrower, any lease that I get will my client will ask, do I need the consent of the lender? And I would say, well, is this on market rate terms? And my client, of course, is gonna say, of course it's at market rate, Jeff. And in that case, I would say, no, you don't need the consent of the bank or lender. And that's great. Now, another way, I mean, so how do you sell that, I guess, is the answer, is the question. Number one is, how am I gonna get the bank to agree to this? And I would say there's two ways. Number one is you tell the bank the truth, which is, I got a sophisticated client, okay? He knows what he's doing. And he's been doing this for many years. He doesn't want to have to go back to you, the bank, and for every lease. And one, deal with the timing issue, deal with the negotiation issues, and deal with the costs. You gotta trust the borrower here. He knows what he's doing. Number two, I would say to the bank attorney, look, even if there's a bad lease and you don't like some things in the lease, when you take over the property in a foreclosure, if there's ever a foreclosure, you can always wipe out that lease. And now why is that? Well, because the mortgage is recorded first, and the lease comes up later. And that means the lease is subordinate to the mortgage. And when the mortgage forecloses, since they're superior, they can wipe out the lease. So the bottom line is, even if it's a bad lease, my argument to the lender is, you're never going to inherit it. Okay, you're never going to have that issue. Now, realistically, I'm not saying it's easy to get that type of language, but it's certainly something to propose. Another compromise is you can bifurcate the leases into major leases and minor leases. And you can say to the lender, look, with respect to the minor leases, I don't want to have to go back to you for consent. Okay? If it's a major lease, I'll go back to you. And then the issue becomes, well, how many square feet is a major lease and how many is a minor lease? And the answer to that is really a function of what how your property is. If it's a strip center that has 25 retail stores and 4 or 5 of them are 25,000 square feet or more, you may want to say that a major lease is 25,000 square feet or more, okay? Because this way you only need consent for 4 or 5 of the leases, which is exactly what you want. But the bottom line is, if you can get that type of a distinction, it's better than where you started, which is you need a consent at all times. Now, I will say that many tenants understand that they are subordinate to the mortgage, and they know they're going to get wiped out, or could get wiped out in a foreclosure. So they don't like that, obviously. So the more sophisticated tenants will ask the lender before they sign a lease, okay, at the same time they sign a lease, they'll ask the lender for what I refer to as a non-disturbance agreement, which is an agreement between the lender and the tenant, which basically says if the lender ever forecloses, they will not wipe out the tenant in a foreclosure, so long as the tenant is complying with its lease. Now, so when that happens, unfortunately, there's no shortcut here, and the lender will review the lease and will give you comments, because they know someday they may take the landlord position under that lease and become the landlord. So in that case, there's nothing really you can do. So that's basically the first issue on the leasing. The second issue to look for when you're a borrower to address is the transfer section. Now, I believe in your mortgage documents, the standard form mortgage you have in section 1.20 is the transfer section. And you'll see that it says that the borrower may not transfer the property directly or indirectly to any third party, okay? So we all know what directly means. That's where one entity transfers it to another entity pursuant to a deed, and it gets recorded. That will be a violation of the mortgage, which will entitle the lender to declare default and then foreclose. The issue of indirect transfers, for those of you who are not as familiar, I always like to talk about something that occurred 50 years ago, which was before my time. And basically, it was what's called the Pan Am Building. The Pan Am Building in Manhattan used to be right over, I'm saying it still is, but it's called a different name now. It was right over Grand Central. And back 50 years ago, there was a transfer tax that New York State and New York City had, which they still have, which basically said whenever you transfer property from person A to person B, or entity A to entity B, there will be a transfer tax of about 3%. Okay, so if it's a $100 million deal, you're going to pay $3 million in transfer tax. Now that's a lot of money. And what would happen is you pay that when you record the deed. When you go to the recorder's office, you take the deed and you give it to them. You got to write a check for $3 million. So one particular purchaser was a little sharp. He was a sharp person, and they said, you know, we're not going to take a deed. We're going to ask to buy all of the stock of the seller. Because the seller here was a corporation. It owned 100 shares of stock. One entity owned it. And what simply happened is that stock was sold to the new purchaser. So the purchaser didn't get a deed. He simply purchased the stock and then became the owner of the property. Now in that case, there was no deed that had to be recorded because it was an indirect transfer. The entity that owned the property was still the owner of the property, just with a different owner. And the new owner said they don't have to pay transfer tax. They saved $3 million, and they were correct. So what happened thereafter, about a week or so thereafter, New York State passed a new law which basically taxed indirect transfers. So if there was ever a transfer of beneficial control of an entity, that would be deemed a transfer. Okay, and you have to pay the tax. This same issue is in all the mortgages. All the mortgages state that if you transfer a beneficial interest in the borrower, that will be a transfer, which is prohibited. So that could be problematic depending on your structure that you have and what your client wants to do. So for example, if we have a limited partnership where we have two general partners, let's say it's myself and Donald Trump are general partners, and we own collectively a 50% interest, and the other 50% interests are owned by limited partners, and they have a 50% interest as well. Maybe we'd like to have the limited partners be able to transfer their interest to someone else without the consent of the lender. Why? Because who cares about the limited partners? They're not guaranteeing anything in my example. They don't have any say in the management of the borrower, because in my example, I'm running it with Donald Trump. We're the important ones. So who cares whether the other 50% ownership interests are transferred? Similarly, I may want to have a provision that allows me to transfer my rights or a portion of my rights to some type of a family trust, for family planning reasons. And that's often negotiated as well. Or there could be a simple provision that everybody has a right to transfer their interest so long as Jeff Feigelson and Donald Trump retain a certain percentage interest, let's say a 25% interest, and maintain management control. Okay? So these are the type of provisions that you have to ask your client about, but it's very important that you take a look at the mortgage and see what your client may do in the future. I might add that sometimes, I would say in about 1 in 50 mortgages, you will get a scenario where the mortgage document itself will allow you to transfer the property pursuant to a deed, so long as certain conditions are met. And the conditions are